Hi, everyone, and welcome to our webinar. Thanks for attending. This is the webinar Navigating Privacy and Compliance Enforcement, a California Privacy Rights Act mid-year check-in. We're going to cover where we stand with the California Privacy Rights Act, talk a little bit about the recent turmoil and delays and the implications of that. And we have a couple of experts on the panel who are going to help us go through their step-by-step process and real-world experience with compliance with the CPRA and similar laws. So before we get started, I just want to do a little bit of housekeeping. The presentation and a link to the on-demand version will be shared with you via email. There's a questions feature in the bottom right side of your screen where you can submit questions regarding the presentation. I will try to get to them if they are relevant to the slide we're on, but otherwise expect them to be held for the Q&A at the end of the presentation. If we don't get to your question, we will attempt to address it in our blog that's going to be published about this presentation over the next 24 hours. You can also visit check.ai/resources for complimentary information such as blogs about recent state laws, ebooks. We have a new ebook which compares every U.S. state level law. It has a really useful chart for comparisons, as well as some details about best practices for compliance with that patchwork of state laws. And so you can get that all at that link. We do have a legal disclaimer, just that this webinar is intended to give a general overview and information about the CPRA and CCPA. It is not legal advice or guidance. If you need legal advice and guidance, please consult your lawyer. All right, so let's do some introductions. My name is Jeff Edwards. I am the content marketing manager at CHEQ. I have been working in the privacy space for 3 years. And prior to that, I had hands-on experience with GDPR implementation. So quite a bit of experience in this space. And our panel of experts who will introduce themselves are Jason Patel. Introduce yourself, Jason.
Hey everybody, I'm Jason, AVP of Engineering and Tech Innovation at CHEQ. And yeah, just like Jeff, I've been working in the privacy landscape for, I think, close to 5 years now, and definitely been a part of various GDPR, CCPA, CPRA, and pretty much any other privacy regulation implementation you could think of.
We also have Akil Anamolu.
Hey everyone, Akil Namolu, joining in as a friend of CHEQ and here to talk about privacy. Been in the space for over 10 years. I've worked at companies like Symantec, Delta Airlines, and most recently KFC, where I was the Global VP of Digital Product and Engineering.
Awesome, thank you guys. You'll hear more from them shortly. I'm just going to give a brief overview of what is the CPRA. I know that if you've joined this webinar, you're probably aware of this information, but we do want to be as inclusive as possible, and we'll go over some of the changes from the CCPA to the CPRA, as well as the delays, enforcement actions, and the implications. So what is the CPRA? So the CPRA is often referred to as CCPA 2.0. It is an act that was established via a ballot measure, Proposition 24, in 2020 that amends the CCPA. It's not actually a law that stands on its own. When you look at the legal text, they often refer to it as the CCPA as amended by the CPRA, where the CCPA gave California citizens several rights, including the right to know about what information is collected about them, how it's used and shared, the right to have that information deleted, with a couple exceptions, and the right to opt out of the sale of personal information, as well as the right against discrimination. The CPRA amends that and extends new rights to consumers, which we'll get into shortly. It also amends the definition of personal data to make it broader, creates new categories of protected data, including sensitive personal information. It alters the scope of which businesses must comply with the law. It raises the threshold in some places, but the broader definitions actually end up giving a wider threshold for applicability overall. And it most importantly created an enforcement agency, the California Privacy Protection Agency, which is responsible for the enforcement of the law, as well as promulgation of new rules. Now, enforcement, as most of you are probably aware, was slated to begin on July 1st, 2023, but it was recently delayed until March 29th, 2024 for key provisions. That is only applicable, however, to the rules that were promulgated by the CPPA, that enforcement agency. They're responsible for having rules done by July 1st of 2022. They didn't make that deadline. They hit the rules on March 29th, 2023. So that's where that new 9 months we've got comes from. And we'll get into that a little more later. So the scope and exemptions of the law, I'm just going to run through this really quickly so that we can get to the important stuff. The CPRA applies to businesses that meet the following criteria, one of the following criteria: a gross annual revenue of more than 25 million, the buying, selling, or sharing of the personal information of 100,000 or more California residents or households. That's up from 50,000 in the CCPA, or the commercial use of the information of more than 50,000 California residents. Those numbers seem pretty big, but if you've got a website that tracks visitors, then you can hit that 100,000 mark pretty quickly, especially if you're doing a lot of business in California. It does not apply to nonprofit organizations, government agencies, data that is pseudonymous or de-identified in the language of the law is not applicable. So that would be data sets that have removed any specific identifying information, cohorts, things like that. And then certain employee data categories don't apply, such as data that is gained in the course of job applications or in providing benefits. The new consumer rights and business responsibilities provided by the law. So the CPRA, in addition to those rights I outlined for the California Consumer Privacy Act, also gives new rights, including the right to correction, wherein California citizens can request that data controllers, i.e. businesses, correct any inaccurate personal information. It also includes the right to limit the use and disclosure of sensitive personal information. Now, that is any data that is focused on race, ethnicity, religion, genetic data, your private communications, sexual orientation, health information, geolocation. That is all required to post a separate opt-out link from your previous opt-out link. There is also the right to opt out of profiling. Profiling is defined as the right to object to automated decision making, which takes meaningful personal information and makes a decision without any human involvement that can have a business impact on the individual. So they have a right to opt out there. There are also new requirements for the limitation and minimization of the collection of data, how you go about getting consent for further data use, and risk assessment requirements are mandated. There's a yearly general cybersecurity audit, which you have to do on an annual basis and turn into the CPPA, as well as data protection assessments, which are done on a need basis. For anyone who processes sensitive personal information or engages in high-risk processing activities, as the law defines it, these need to also be submitted to the CPPA for review. Finally, there are contractual requirements for third parties. So if there's a contractor that processes personal information on your behalf, it needs to be in the written contract that they will prevent the sale and sharing of that data to fourth parties. There needs to be certification that the contractor understands the restrictions of the CPRA, and they need to permit the business to monitor your business, to monitor the contractor's compliance with those rules. And that it can be a pretty difficult thing to achieve. So we'll talk on that a bit later. Now, finally, the consent requirements as updated by the CPRA. There is a do not share my data requirement in addition to the previous do not sell my data requirement. So what is the difference between selling and sharing? Sharing is communicating by any means a consumer's personal information by your business to a third party for the purposes of cross-context behavioral advertising. Now, that is not just for monetary or any other valuable consideration, it's for any purpose at all, including those where no money or value is exchanged. Cross-context behavioral advertising is the targeting advertising to a consumer based on the consumer's personal information, which has been obtained via activity from sources other than your business or service directly. So any third-party data whatsoever. If a consumer opts out of the sharing, businesses are responsible not only for what you do with the consumer data, but also what third parties do with the data. For example, if you post website ads from a third party, you must ensure they do not store or collect consumer data that has opted out. That requirement extends to services like trackers, telemetry, online assistance, and shopping carts, etc. There is also a limit the use of my personal information, sensitive personal information link required. We can't cover that before. Any of that SPI that I outlined on the previous slide, you need to provide a link in your privacy statement to opt out of the use of that completely. And then in special cases, there is opt-in consent required. Mostly minors under the age of 16 must be given an opt-in consent prompt before their data is processed. Financial incentive programs also require opt-in consent, scientific research, and a couple other reasons. The CPRA also changes the definition of consent. It is now defined under the same lines broadly as the GDPR as freely given, specific, informed, and unambiguous. Now that is a hedge against dark patterns, which have been defined by the CPPA in some of the further rulings. They made rules against patterns and designs which are intended to trick someone into opting in when they don't want to, or to take an action that they did not mean to take. Those rules and promulgation of those rules, the exact definitions of dark patterns, have not been accepted now until the new deadline of March 29th, 2024. But it's still important to follow them and to do the right thing, because dark patterns are restricted under other privacy regulations, GDPR, for example, Colorado, which just went into effect, Connecticut as well, which just went into effect on July 1st. There is also no retaliation for opting out of data sharing or tracking. So if someone exercises their consumer rights, you can't just unilaterally block them from using your service in retaliation. And finally, businesses must honor global opt-out signals, such as the global privacy control. These are settings in the browser or device that signal to the client side that we don't want to be tracked, we don't want our data sold or shared. Those requirements are kicked back to March 29th, 2024. But there are similar requirements in place in Colorado, which have yet to be fully defined and will take place in 2025. So CPRA enforcement, what can you expect? Enforcement is undertaken by the California Privacy Protection Agency. They have the right to fine businesses that violate the CCPA or CPRA. $2,500 per fine, $7,500 per negligent fine, and an additional $7,500 per fine that involves the information of minors. That may sound like a low dollar amount, but when you consider a spreadsheet of thousands of customers that is potentially unauthorized access of that, each customer constitutes a fine, and that can add up quite quickly. Consumers in California also have a private right of action wherein they can sue for damages of the unauthorized access to either non-encrypted or non-redacted personal information, such as name, address, driver's license number, sensitive personal information such as that. And then the CPRA has extended that requirement to address and include passwords and security questions, email addresses and answers, anything that would permit the access to an account. There was a 30-day cure period under the CCPA in which the Attorney General, who was responsible for the enforcement of that law as it was written at the time, was required to give a notice of violation to violators, and they then had 30 days to remediate that violation, and they would not be fined if they did so within the 30 days. That cure period, the expiration of that, was actually written into the ballot measure that passed the CPRA. So that has expired as of July 1st. And now the Attorney General and the CPPA have discretion to offer cure periods. So they will look at a violation. If they determine that it's purely accidental, they may offer a cure period or may not. If they decide that it's negligent or malicious violation, they will not offer a cure period at all. Now, the enforcement delay here, we've covered a little bit, but that delay is only related to provisions that were not finalized in the initial deadline of July 1st, 2022. So the argument that was brought forth by the California Chamber of Commerce in a lawsuit said that the intent of the law was to give businesses a full year to prepare for provisions. The court kind of struck a balance between enforcing the law and delaying the law. They say that any provision has 1 year before enforcement after it is finalized. So a lot of the rules regarding the opt-out preference signals, specifics of opt-out mechanisms, data processing third-party agreements, as well as dark patterns, as I mentioned, and some consumer request handling specifics have been delayed. But a lot of the amendments to the actual CCPA remain in place, including the loss of the cure period, and the CPPA still has the authority to enforce the CCPA, and they have indicated their resolve to do so in a meeting in March this year. They said that enforcement is a top priority, and they will be hiring official personnel to do so. So with that in mind, we know that enforcement is delayed, but they do still have the capability to enforce certain provisions. Where do we think that they're going to look to enforce, and where are they going to focus first? If we look backwards at where regulators have already focused their enforcement efforts, where the California Attorney General has focused, and then if we look overseas to the EU, where there has been a lot more enforcement, even though that's a stricter law, we can take some lessons away from that. So looking at the enforcement actions of the California Attorney General, we can see that the majority of violations are related to the failure to honor consumer rights, things like insufficient privacy policies, as well as improper responses to data subject access requests. The public settlement against Sephora for $1.2 million, for example, was related to privacy notices and the right to opt out. And then looking at a lot of the case examples that the California Attorney General provides for enforcement actions, we can see here that you have erroneous treatment of requests to know, you have failure to honor consumer opt-out of sales, and you have non-compliant opt-out processes. If we look at the EU, we see more of the same. Insufficient fulfillment of information obligations, i.e. the privacy notice violations, have resulted in 150 GDPR fines, and consent-related issues are attached to over 495 fines. I think that the combined monetary amount of those fines is over $500 million. So that's no joke. So why are the regulators looking at these provisions? The answer is pretty simple. It's easy for them to look. It's easier to check a privacy policy or an opt-out process, or even to submit a DSAR than it is to go in and look at data security requirements and to do an audit and things like that. There are even privacy-focused nonprofit groups, such as the NOYB in Europe, that do this on their own. They will write a script that goes and checks the opt-out or the consent management capabilities of 500 websites in the top 500, and then they will submit any violations to the authorities. We saw several examples of that going all the way to a fine in Europe, and we could imagine the same happening in the US, especially where there is a potential in the case of unlocked down information for a class action lawsuit in California. All right, so that's the overview of the CPRA. And now I'm going to hand things off to Jason and Akil, who are going to go through some of their real world experience implementing compliance programs, starting out with a checklist of what you should be thinking about when you approach CPRA compliance, and then a focus on technical considerations, as well as how you can implement compliance with some limited resources. As we know, this is a difficult time in the economy, and compliance teams, not being a revenue generating department, may not have all the resources they desire. Okay, guys, so Akil and Jason, how do you guys approach starting a compliance program? What is your first step, and how do you take it through to completion?
Sure, I'm happy to start here. So, what I've done in the companies I've worked at is first we identified who the compliance team was, as you've got listed here. Who is entailed in the compliance team is probably the biggest question. The thing is, compliance is across many different departments, divisions, and groups. So the easiest way to kick off is number one, who is the point person for privacy? Is it the CISO's office? Is it the legal department? Is it digital? Is it marketing? Is it IT? From the companies we worked at, we decided it was digital product. Why did we do that? A couple reasons. One, digital product has a lot of interaction with the different groups that I just named. Two, we're the ones actually overviewing and seeing the products that we're developing and putting out into the digital lens. And then three, we decided a lot of the MarTech ownership, especially deployment of trackers, pixels, analytics, and so forth, were centralized into a COE that was owned by digital. So we said, okay, digital is going to be the point person. Now, how do we ensure that the rest of our partners are aligned in agreement with that? We took it to the table with them with a playbook and said, hey, here are the laws coming down, such as GDPR, CCPA, and so forth, where we have to be very thoughtful about it, right? There's a lot of technical acumen that's needed there. There's a lot of business acumen. And then there's also revenue generation implications by how these laws are being enforced and how they're being complied with. And we said, how do we find the right ground? How do we find the right need for capabilities? So it was very imperative that we worked with the marketing, legal, IT, and information security to find that ground. And we became really good friends actually with the legal team more than anything else, because legal, between internal counsel and external counsel, they are looking to define these laws, understand what it means for our company. And a lot of times, them, along with the CISO office, they really want to go to the extreme measures saying, let's just block everything. While on the other side, you've got the marketing teams saying, actually, we need everything because this gives us more capability, more ability to target, more ability to personalize. It should give us more revenue generation. So we have to break it down very, very subjectively and say, hey, here's what we can do. Here's what we can't do. Here's what we shouldn't do. And what is the value of each of those pieces, and take it back to that council and with that playbook and say, hey, can we all come to an agreement of what we're going to be allowing our company and digital capabilities to take and process versus what we're not? And also, what is the process when we have requests against removal of data, updating of data, and who is that going to go to? So it really came down to a group effort and bringing these pillars all together because, like you said, Jeff, it may not be revenue generation, but it's a lot of cost savings that helps the company at the end of the day.
Absolutely. And what were your first priorities once you had identified the team? What would you tackle first in terms of the business obligations?
Sure. Business obligations was number one. Meeting with our marketing teams and agencies. What is the data that you're tracking? What is the value that you're getting out of it? Why are you tracking it? Where is it going to? A lot of times what we found is our marketing teams, they want everything. And especially the agencies, they want any and everything in there. But we have to be very thoughtful on what's being collected, what's being allowed, and how to even opt out of it. So what we did was we implemented a lot of privacy capabilities that said, one, let's figure out where our data is going. And what we found in some of the privacy audits we found was a lot of pixels were piggybacking more than anything else. We would say it's going to vendor or MarTech supplier A, but then it was subsequently being sent to B, C, D, and E. And we said, hold on, we've got to be able to control this first and foremost, because like you noted before, we're responsible on where third parties send it. So we said, hey, we don't mind information being sent here, but we need to be able to track it. We need to be able to monitor it. We need to be able to shut it down. So instead of you all loading up a bunch of iframes or a bunch of JavaScript pixels, let's load up image tags, pixels. Let's control where this data is going and monitor all of this through our tag management system. And then with that, we took that almost like an audit to our legal team and CISO team and said, hey, here's what's going on. Here's how we define it from a technical lens and from a marketing and revenues capability. Does this comply with what you all see from a legal and information security basis? So we really, to kick off, we had to spend a lot of time locked in a conference room going through some of these nuances. And part of that is also educating these other departments and these other departments educating us. We're not legal experts on the digital product side. We're not marketing experts. Likewise, our marketing counterparts are not going to be digital experts every time, and our legal are not going to know digital. Same with the CISO side. So it was actually building those bonds to know that we trusted each other and we're doing what's best for the company at the end of the day, as well as our consumers.
Excellent. And once you had determined responsibilities and determined your program, how did you create a playbook for ongoing compliance? Was it then you had your compliance team that implemented the program? Did you then hand off to a compliance team that was to get it continuing and to handle DSAR requests? Who was your primary legal contact? How did you handle that?
Sure. First of all, because we decided digital was going to be the point of contact, we had a dedicated product manager for it. Now, this product manager did have other responsibilities. We knew, just like most companies, we were resource limited, so we can't just pay for one head to only do privacy and compliance. So it was part of their role. With that also being said, any requests that came through, we decided went to a distribution list. That distribution list included points of contacts, both on the digital product side, marketing side, and most importantly, the CISO office, as well as the legal office, because they were going to dedicated people in those groups who had focus and specialty in this space. And that way there was also a versioning and tracking record of every request coming through. A lot of times we would actually see the same actors keep asking to either remove information, alter information, or they were trying to find ways that we were not in compliance. So sometimes our legal team would actually take that, keep a documented history of it and go back to the right government agencies and say, hey, we're trying to be compliant here. We are staying compliant, but we're finding that these actors are doing this in a way that it's not intended based off the law. They're trying to be malicious almost in a way to try to catch us when we're trying to do everything that we can. But also keep in mind, we're a company that does have only X amount of resources. So we need time to be able to adjust and take care of these requests that come through.
Absolutely. All right, so that is a pretty good overview of readiness for the CPRA. Now let's talk a little bit about some of the technical considerations for CPRA compliance. And Jason, I'm going to loop you in here quite a bit because I know you are the expert here and you've got a lot of experience with this. I wanted to talk about, first of all, managing alternate consent options. The CPRA does require the recognition of a universal opt-out method. That is now kicked back to March 29th, 2024, which I'm sure is very welcome for a lot of our listeners today. I just wondered if you could take us through how that works and how people can implement that recognition of universal opt-out methods.
Yeah, totally. So the main one that the CPRA refers to is GPC. With the Sephora ruling, it kind of like blew up the internet and we all suddenly became experts on it. But those of you that are familiar with, like, say, D&T as it used to exist once upon a time, this is kind of almost like the second version of that, right? So GPC is basically a way of putting a setting in your browser to say any website you visit, that like if it looks, it will see that you've opted out of tracking, right? And then it's that website's job to respond to that, right? So there's some JavaScript you could read, or like there'll be extra data on the requests that come out of the browser that it could receive server side. There's a bunch of different ways to handle this actual requirement, right? So on one side, you can make sure that whatever consent management platform you're using picks up that GPC signal, turns on whatever opt-outs, and like make sure to suppress whatever tracking technology or alter them in accordance to whatever your privacy stance is. On the other side, you could hope that your vendors actually look at that GPC header that gets set on the requests as they leave the browser and drop that incoming data as well. I think the one thing also probably we should be aware of when we think about GPC and like that language that the CPRA has around universal opt-out method is that, the text doesn't necessarily define a specific universal opt-out method. So when we go ahead and start rolling out our compliance strategies more materially in a technology form, right, you need to make sure whatever solution you use is going to be flexible enough where if another universal standard emerges tomorrow or becomes ubiquitous, we could adapt to that really easily, right? Rather than having to wait for, California has like decided this new government browser plugin is the valid way to opt in and opt out or something like that, right?
Yeah, absolutely. And just want to throw in that the regulation says that if you are recognizing a universal opt-out method, you are allowed to remove your other methods for opt-out from your privacy policy. So it's clear that regulators want this to be the new de facto method of opt-out. But also, if you have removed your other opt-out methods and then a universal opt-out that is maybe a new standard that's recognized, it doesn't work with your system, you can get hit with fines for both an insufficient privacy notice and insufficient opt-out, which can be a pretty big deal. Now, another challenge that emerges when you're managing compliance, especially with a large company with a lot of different digital properties and platforms, is that you might not be using the same technology to enforce and implement compliance across each site, and you might be using dozens of different third parties to track users across all those platforms. What are the challenges of integrating consent and compliance across all those different properties? And what are some solutions to make that process easier?
Yeah, absolutely. So, I always look at the challenges in kind of two forms, right? There's a technology challenge and a people challenge. So I think the technology challenge, anyone that's a practitioner in the martech ad tech space probably is very keenly aware of. And Akil even talked about this earlier today, where your technologies might be leveraging other technologies in order to perform their function, right? So are you sure that all the data that you're sharing is for analytics purposes, or is some of it going to get used for advertising purposes as well, right? Are you sure that the technologies that you're using on your main site are the same technologies that are using on your microsite? Are you using them in the same manner between the two, right? We know that some MarTech can perform multiple functions, right? So on one side, you could just leverage it for analytics, customer engagement, but on the other side, you could actually convert that data to advertising and targeting too. So understanding how that data is being used, how it's being implemented. Then on the people side, when we look at like a lot of these more sophisticated or larger organizations, right? And especially in this economic environment, there's a very little chance that you're going to be doing everything across all your brand touch points yourself, right? You have maybe your homegrown internal martech team, and you guys maybe focus on your main property, right? But you guys are probably running some microsites, some summer campaigns, maybe 4th of July campaigns. They're going to be run by outside agencies, outside partners, right? How do you make sure that those companies that are representing your brand, tracking users for the benefit of your brand, are actually staying in compliance with as how your brand defines it, right? So that's the other challenge, right, as far as oversight. So there's a couple different ways to handle this, right? So there's the traditional method where it's like, you could look at process and policy, right? And this is kind of like you see a lot of mirrors between privacy and cybersecurity when you talk about like how to do this enforcement, right? Cybersecurity, a lot of times we talk about process and policy as well, making sure everybody follows the first 10 steps, does all the checklists, documents everything. And if you could get your organization to actually follow those steps and do so in a way that doesn't detract from business velocity, maybe that's a manageable solution for you. On the other side, right? Again, like we have a lot of people with a lot of fingers in the pot. Controls and automation might be the better approach, right? How can I just set up layers of my platform or whatever technologies I'm leveraging for compliance to make sure that regardless of what personnel are operating on behalf of my business, whatever they try and do, it will be either restricted or permitted based off of my own company policies, right? And then having that oversight ability. So I think that the actual solution depends on what's the company culture? Are you guys a process policy oriented kind of company? Are you guys kind of one of those lean mean machines where you try and automate and leverage controls wherever you can so you can focus on revenue generating stuff? It's not a one size fits all. You could do it a couple different ways, but there's pros and cons to both.
Absolutely. And Akil, is that a challenge that you faced in your career, keeping kind of all of these disparate entities in line? And do you have any specific examples?
Yeah, no, it was definitely something of a challenge every place I've been at. And some of the ways we addressed it, I think, are definitely practical ways that any company can do it. I think number one is one, we want to trust our partners, whether they're agencies or technology partners. So when we set up this playbook, we set up standards when it came to data collection, when it came to deployments. And we said, hey, partners, one, when you join with us, let's say you're a longer term partner and we have a multi-year agreement, you go through a quick training with someone on our team around this compliance, around what we're doing, around our tag management. And from there on out, you're free to leverage and deploy as needed. But we're going to do quarterly audits of everything that you've deployed because we have versioning control, we have user tracking and everything like that on who did what. And on top of that, we're going to put SLAs in our contracts that state if you do anything that puts us at risk or does not put us or takes us out of compliance, you will be financially liable for that. And you will be further liable if there is an actual legal issue that arises from this. It's one thing if they do something and we're able to catch it and amend it. It's another thing if they do something and it becomes a public facing issue or a legal compliance issue that gets picked up by any sort of auditors externally. And by doing that, we found a lot of our agency partners and technology partners became very compliant. They followed our process. We saw very few, if any, issues. Now, for those one-off partners that we would get maybe for like a limited time campaign or a one-off campaign, we said, look, we're not going to allow you access into our systems. Tell us what you need. Give us the reasoning why. We're going to keep a log of that, but we're going to handle the deployments and manage it for you. And we would give them an actual time frame of when these deployments could happen and what is all going to be tracked in there or what can't be tracked and why we can't do it. On top of that, every time we went through these deployments, we had to make sure our privacy policy was managed and updated. And that's why we had a product manager who would oversee that. And then likewise, a set of that information was always copied over to our CISO and legal team. So we made it a very repeatable process that would just kind of almost become autopilot.
Yeah, that's excellent information. Sort of similar challenge is the challenge of dealing with all of these different regulatory environments. You know, we have 10, potentially by 2026, we'll have 12 different state level laws in the US. And then, of course, there's the GDPR as well. What, in your experience, was the key to managing both compliance and customer experience as well as business goals across all these different regulatory environments?
Yeah, no, I think when like GDPR first came out, there was a lot of questions, right? Because the laws were very ambiguous. And if we think about the core of it is we have to remember not to remember you. It's kind of oxymoronic to an extent, right? So remember, this is an iterative process, right? Yes, rules and laws are set out, but they're going to keep changing. Likewise, your policies, your structures, and how you deploy and maintain are going to keep changing and iterating. Now, there is a balance, right? You're obviously balancing revenue generation versus privacy, and that privacy basis also can have a cost component if you're found not in compliance. So when you're going through that balance, it's one, making sure everything that you're doing, legal is signing off on, both your internal counsel and your external counsel, if your company uses both, and making sure that they're on board because they can help defend and define what you're doing and why you're doing it. The other side of it is, while the laws like CCPA state you cannot remove functionality, you can say by not having this information, it's going to limit the ability we have to give you tailored experiences or capabilities. And making sure that the customer understands here are the benefits of them opting in and giving that information, and then the discrediting why removing that information is going to be a problem. Another part of CCPA that I actually think is a benefit that I really think marketers and digital personnel should take advantage of is correction of information. How often do we ask customers to correct their information? Let's make sure we have it right. Let's make sure we are tailoring this to you. Tell us what's going on. You know, actually, companies that do this really well are banks. Banks, credit institutions. There's a lot of times you log in, they say, hey, can we make sure your information is correct? Is this your right email? Is this your right address? What about your financial basis so we can make sure your credit products are correct as well? And we're giving you the best rates possible. Using some of that same UX, UI, how do you bring that into your ecosystem as a digital marketer, as a digital product person, and say, hey, let's use this as a basis to promote people opting in and making sure their information is correct so we can provide them better experiences at the end of the day.
Yeah, absolutely. Now, spinning off of that, which I liked a lot, remember not to remember you. Jason, one of the most difficult things about compliance with these laws is the ongoing enforcement of that opt-out and of consumer preferences, because if you are not supposed to track them, then how, I guess, would you remember not to track them? Can you talk a little bit about the requirements for opt-out enforcement and where some solutions might come short of that and how it should be done correctly?
Yeah, absolutely. So, you know, I'm paranoid for lack of a better word. So, the one solution I generally never really endorse is like kind of the hope my vendor handles it solution. So earlier I mentioned that like, either via DNT or GPC or, maybe setting a setting on a pixel and hoping that like, the vendor, when it collects the pixel, reads that setting and realizes they can either keep or drop that data, right? As someone that would be responsible for a company's compliance, right? Like I kind of consider that a pass the buck model, right? And at the end of the day, right, like I don't think that puts you in a very defensible position, right? Where if like the California Enforcement Agency asks me, show me evidence of compliance, show me that you're performing these activities, right? Like what's my real answer, right? It's like, oh look, I set these attributes on the pixel, now go talk to that vendor and let them look at have them look at your technology and make sure that like they're actually respecting these settings. It's a tough sell, right? For me, I like to usually go for demonstrable compliance. Show me these pixels are being suppressed, right? Show me that I'm making different business decisions based off that data that's I'm not getting potentially, right? And then, as far as how do we record that opt out, right? Yeah, this is like kind of a tricky question, right? Because at the end of the day, at this point, right, like there are carve outs that you've seen even in GDPR that's a little bit more mature, and like with CPRA and CCPA, like where, yeah, you could drop a cookie or something like that to manage those users' preferences, but it's up to the brand as far as like how long they want to preserve that cookie, how they want to leverage like any identifier to make sure that whenever that user lands on that site again, you can bring back their preference settings. So, in some regards, kind of to Akil's earlier point, where like, hey, maybe getting users to kind of lean in with you and like, decide what data and what not data to share to improve their experience. This can actually help with that, right? If I'm having a user come in and say like, look, I'm not okay with sharing my data for advertising purposes, but I'm okay with you getting my data as brand XYZ because I like engaging with your brand, right? As brand XYZ, I want to make sure that I want to deliver that best experience to that customer, right? I'll probably store that data. I hope that data can get back into my CRM, right? Whatever compliance strategy I'm using, I want to make sure that that gets back into my CRM, my marketing automation layers, right? To make sure that both that customers' preferences are respected every stage of outreach or marketing, but also that when I build that trust with them, so when they come interact with my brand, right, they're willing to share at least data with me, right? So I can provide them the best experience and make sure that, okay, I don't need to hammer them with ads across the internet constantly for them to come back. They keep on coming back because they had such a good experience with me in the first place.
Yeah, that's a great point. Okay, so I just want to jump into our final section before we get into our wrap up and then the Q&A. And that is managing compliance with limited resources. There's a lot of people on this call, I'm sure, and out there in general who are struggling to wrestle the giant like bear that is California compliance, Virginia compliance, GDPR compliance, etc. It's a huge workload. And a lot of people have attempted to set this up as a manual process and find it's not scalable. I just wanted to get your input, Akil, about what are some best practices to take care of compliance when you have limited resources. We may have lost Akil for a second here. Oh, there you are, Akil. Did you hear that question?
Sorry, I did not.
Oh, that's all right. I just wanted to jump into managing compliance with limited resources. In your experience, what have been the best practices for ensuring that compliance is an ongoing scalable process and that it's not taking a ton of employee hours to handle the huge requirements of these laws?
Yeah, I think number one, having the right technology partners is key to all of this. So being able to automate this as much as possible makes life the easiest, first and foremost. Two, having that playbook and knowing who the points of contacts are and making sure that that's a streamlined process also helps and be able to enforce this at scale. And then three, like I talked about, ensuring your technology and ad and agency partners are following these rules and knowing that they have a contractual obligation to do so helps get you there, right? Beyond that, then it comes down to a company by company basis, right? We were lucky in the companies I worked at that I was able to take a person, dedicate part of their time towards this. Some companies may not be able to. Well, they'll look at external partners to help them do that versus having the internal resources. Likewise, at the companies I'm at, we also said, given our other digital properties, given our subsidiaries, we will also build a COE and manage it here. And whatever propagates out from the COE is going to be enforced and followed like the rule of law at our subsidiaries and other digital properties as well.
Excellent. Jason, could you talk a little bit about the challenge of observability of what is happening on your website and evidence gathering for any issues or violations and how you would actually remediate attempted or actual violations?
Yeah, absolutely. So, again, like kind of back to some of the real world examples that like Akil had given around like making sure we have like process and procedure in place, but as well as controls to help automate the standard along the way. So we don't need to just constantly have like, check in, check out processes that like, we could do something quarterly then versus every single release, right? Where observability and evidence gathering come in is like, especially with that new risk assessment requirement, right? You're going to need to maintain inventory of what the heck's running on your site, where it's running on your site, and then on top of that, from an observability perspective, right? You'll also want to know like, hey, where are potentially the violations already occurring or at least being attempted to occur on my site, right? Hopefully you have a solution in place that at least stops the violation from happening, right? But just like in cybersecurity, if I have like, some like malicious botnet that's hammering my firewall, and even though my firewall is handling every single request and making sure it gets killed, I still want that botnet to get shut down, right? Same way in the internal example where if I have like, a bunch of pixels that are deployed that are out of compliance with my standard of privacy or and yeah, maybe my solution's taking care of it, making sure that they're suppressed and whatever else, right? I still want that behavior to be stopped because at the end of the day, it still poses risk to my compliance posture, right? What if those technologies change in the way they operate and they figure a way out of collecting their data, right? What if someone actually disables my enforcement solution on the site, and not only am I out of compliance for sharing data with my approved partners, but now just shared data with a whole bunch of people I don't even have contractual obligations with, right? I think also there's the other part that we forget too, where with privacy there is like a bit of a, I don't want to say blowback effect, but it's going to affect your job as someone on the revenue generating side of the fence, right? A lot of times, like for the last 10 years, we've gotten really, really good at tracking information about users, not necessarily having to understand all of it, let's be honest, right? And then being able to target them across different channels and different purposes across the internet, right? And these new regulations will affect our ability to do that, right? We can't just say like, look, I turned on all my compliance strategies on my site, and I'm just going to assume my ad strategy doesn't change, my SEO strategy doesn't change, right? Because at the end of the day, all this stuff is interconnected, right? So understanding which technologies are being affected at what rates can affect everything from your like marketing advertising strategy to even potential things like, what vendors do I want to invest in? If I have a vendor that's being opted out at my 100% rate, right? Do I really want to renew that contract with the vendor? Do I just want to remove that vendor off my site? Because like, look, at the end of the day, yeah, that request is never being fired, but like maybe it's adding to page weight. I could get some performance back because, I'm not getting any benefit from a data gathering perspective, stuff like that. Also, like, where did someone violate my data collection activities on site, right? That I like, as Akil mentioned, like some of these agencies, like they collect everything, right? So, I would like to know that if I set up a form page somewhere and like one of these agencies is just like shooting emails off to like another vendor or like an ad partner, right? Like Where is that happening? At what rate is that happening? Is it frequent, right? Whose behavior do I need to correct? Where do I need to actually correct a collection strategy on site as well?
Yeah, absolutely. That visibility is so important. Cannot understate that. So in the interest of time and getting to our Q&A session, I'm just going to run through this really quickly. Just given the delay of the CPRA, it might be tempting to take your foot off the gas when it comes to compliance. We just want to, give an overview that it's not the only law happening right now. The July 1st enforcement deadline, that was also for Colorado's Privacy Act, for the Connecticut Data Privacy Act, and both of those did go into enforcement. And so far this year, there's actually been 5 additional states that have passed laws, bringing the total of states with laws on the books to 10 states. That is California, Virginia, Colorado, Connecticut, Utah, Montana, Tennessee, Iowa, Indiana, Texas, and then we have Oregon and Delaware, which are not included in the 10. They are just awaiting an executive signature to finalize those laws. Each law kind of follows similar guidelines, but there are a lot of differences. Scope of applicability, definitions for key requirements. For example, Texas law requires opt-out rights for synonymous data. That's a first in the US. And then many of these laws also require opt-in consent rather than the opt-out framework for sensitive personal information. All of the laws based on the Virginia Consumer Data Privacy Act take that approach. So that would be Connecticut, Virginia, Colorado, Texas, I believe, as well, and Montana. So, there's a lot of variation here. There's a lot happening. The federal legislation was stalled last year. They couldn't come to an agreement on whether it would supersede state laws or not, but they do expect to revisit that in the next session. And then even the FTC has signaled an increased interest in enforcement of existing laws. They've sent out a couple of several $100 million enforcement actions so far based on dark patterns and then on COPPA. So there's a lot happening, and it's very important not to take your foot off the gas when it comes to compliance and to stay focused, because that March 29th, 2024 deadline is going to be here before we know it. It's only 9 months, which we all know can feel like a really short time in business. So with that said, if you do want to learn more about these laws, you can go to CHEQ.ai/resources and download our free guide to U.S. privacy laws. It's about a 40-page ebook covering the 10 laws that are currently signed and have enactment dates. We will be updating it to include Oregon and Delaware if and when they are signed and enacted. And there is a comparison chart you can use in that document to see the differences between the laws on the main consumer rights as well as business obligations. Now, Jason is going to tell us a little bit about the CHEQ privacy compliance enforcement tool.
Sure. So for those of you who don't know, CHEQ is the go-to leader in the global leader in go-to-market security. So we protect both your on-site experience, protect your customers' privacy, and also protect your inbound experience by making sure your paid channels and sites are protected against fraudulent ad spend or fraud traffic, stuff like that. And sorry, go ahead. And how do we help with the privacy problem, right? So we obviously have a privacy platform in our solution. And one of the things that we provide out the gate is you could get the straight up consent modals, stuff like that, right? Get some visibility into what consent is happening on what in what environments across your properties, in what rates across what categories you support, et cetera, et cetera. But beyond that, right? If we go next slide, please.
Sure.
We also provide a large wealth of data, and this data kind of helps address a lot of the problems that we had mentioned earlier on the call, right? So when you're talking about building out a risk assessment, right, you'll need to understand what technologies are being flighted, where, when, why, right? And on top of that, right, you'll from a practitioner perspective, right, you'll want to understand why are things being blocked, right? Did they violate some data policy that, maybe I'm allowed to collect data on this user, but I just collected the wrong data. Let me make sure to correct that. So now I can start capturing any other metadata that might be legally allowed to, right? Maybe I can understand like which vendors are not going to be that efficacious because of their opt-out rates and stuff like that, right? So getting that visibility into not only what that how your users are engaging with the consent experience, but also how is that consent and privacy settings interacting with your digital strategy, right? That's the value that we provide to your business.
Yeah, and if you would like to schedule a demo of privacy or learn more, you can visit check.ai/privacy-demo for a demo, or our contacts, our emails, Jason and I's emails are at the end of this presentation, and you can just send us an email with any questions regarding privacy laws and privacy enforcement or the product, whatever you need, we're happy to answer. All right, so we did have a couple of questions come in. Looks like most of these are for you, Akil. First, we have, what went into the decision-making process when weighing between whether you wanted automation in your enforcement or your compliance process or controls versus a process and workflows?
Yeah, no, great question. I think, some of the decision making, honestly, was how is this going to impact revenue generation? How is this going to impact our customer experience, first and foremost? And then that too, beyond that, on the other side is how is this going to affect us from a basis of being in compliance, and what blowback could we get from this by not being in compliance, or kind of going with a blanket experience versus a more tailored experience. So we put that out and laid it out on paper when we brought those groups I talked about earlier all together and said, hey, how are we going to balance this together? Let's everyone kind of make our arguments, let's make our basis here, but let's also do this with the basis of keeping the customer in mind. And we are not the customer. The customer are those who are coming to us and telling us what they want to do with us, how they want to do it, and then what are the rates of which they want to engage with us and what value they're going to get. And by putting the customer first, we were able to come to pretty unilateral decisions to say, hey, this is what we're going to do. This is what we're not going to do. This is where legal is comfortable. This is where legal is not comfortable. Same likewise with the CISO office as well. And when we decided to go forward with what we came to a decision on, we said, hey, we're going to automate as much as we can because we are limited on personnel and resources. And then the other side of it is we're going to start and we're going to keep iterating. And we're going to have a regular cadence quarterly of how we iterate and do that. So that way we are personalizing this based off the laws that are being implemented in these different locations. So we're not going to create blanket capabilities. We're going to tailor it. So GDPR is going to get this, CCPA is going to get that. Likewise, as other states and countries come on board, we'll tailor it based off of what's coming out there, because we can see a differentiation based off all the reporting that we have, that sometimes greater information or specific information provides more value than others.
Yeah, great. We have another question here. How did you navigate the discussion in using either one global solution for compliance or using an approach with a bunch of separate solutions?
It honestly came down to resources at the end of the day. If you only have a limited number of resources, how can you manage multiple different vendors' capabilities, right? Sometimes simplification and starting and then iterating and growing it and showing the value is the most important. You're not going to boil the ocean from the start and get it all done. So start simple with one solution, build it out, show the value of what you're able to do and what you're able to help the consumer and the company with, and then start to iterate from there. At the end of the day, you can have all the technology you want in the world, but if your people and company are not on board and you don't have the right expertise towards it, none of it is going to be useful.
Awesome. Well, that is our time. We do have one more question, and I will address that in the blog about this webinar, which will be up in the next 24 hours with just a summary and some of the key points made, and we'll share that with attendees. I want to thank everyone for attending. I want to thank you, Akil, for joining us and providing your expertise. If anyone in the audience has any further questions or needs input on these regulations or on privacy best practices, you can contact us at our emails listed here. Jason and I are absolutely open to questions. And then if you'd like to add Akil on LinkedIn, there's his LinkedIn there, and he could field some specific questions. Although, if you do have sales inquiries, please reach out to Jason or I. Okay. Thanks, everyone. We really appreciate your attendance. and we will be in touch with further resources. If you need anything, feel free to reach out. Thank you.